Assalamu alaikum, and welcome back to our channel, True Courtroom Stories.
It's great to be back.
We're so glad you could join us. And if you're enjoying what we're doing here, we'd really appreciate it if you could subscribe to the channel.
Maybe like and share it with your friends. It honestly helps us out a great deal.
It really does. So today we're jumping into what is episode 96 of True Courtroom Stories. And this one is based on some really fascinating research by the constitutional and corporate lawyer, Mr. Zahir Ahmad Mir.
And it's a powerful one.
It is. I want to start with a question for you, for everyone listening. What if the oldest, most revolutionary constitutional principle in governance wasn't really about defining the extent of citizens' rights, but about defining the extent of the ruler's fear?
The fear of the law, you mean?
Exactly, the healthy, operational fear the powerful should feel toward the law itself.
That's a provocative and I think a necessary shift in perspective, isn't it? It immediately reframes the whole conversation.
How so?
Well, it moves us from simply, demanding justice to imposing absolute non-negotiable restraint on authority.
Right.
True equality isn't just something that's written down. It's established when the strong know with absolute certainty that they are utterly and immediately accountable.
Exactly. And that concept, the accountability of the powerful, that is the foundation of our deep dive today. We are unpacking this remarkable piece of source material.
The title is Equality Before the Law, Hazrat Umar, R.A., and the Governor's Son When Power Failed Before Justice.
Research by Mr. Zahir Ahmad Mir, as we mentioned.
And our mission today is, I think, crucial for anyone who really wants to grasp the mechanics of justice. We are distilling how this ancient foundational case study regarding legal equality, a principle that predates most Western constitutional documents by a millennium.
1,000 years. It's incredible.
It connects directly to contemporary jurisprudence. We're going to be drawing some very clear linkages, as the source suggests, between this historical event and rulings like R.V. Prince Ernest Augustus in the UK.
And also the robust equality jurisprudence under Article 25 in Pakistan.
Exactly.
So this deep dive is for you, the learner, who needs to grasp the essence of constitutional equality. That exact moment when high status decisively fails to supersede justice.
We're really traveling back in time.
We are, not just to read a document, but to witness a moment of intense political drama and really judicial courage. Okay, let's unpack this. We are stepping into a world where privilege was the defining feature of society. To witness a revolutionary act that fundamentally changed the relationship between the ruler and the ruled.
It defined the boundaries of state power forever.
It really did.
And what stands out in the source material, for me, is its use of a single visceral anecdote to illustrate an entire constitutional framework.
It's not just a story.
No, it's not just a moral tale. It's a masterclass in the raw mechanics of enforcement. It shows how central authority can bypass local corruption and deal directly with high-status offenders. The story is the law made manifest.
That distinction you just made between morality and mechanics, I think that's key. A moral rule can be ignored, can't it?
Easily.
But a mechanic, once it's applied, it fundamentally changes the entire structure.
It changes the machine of government itself.
Let's start with that revolutionary standard, the one established by Hazrat Umar during his caliphate. This isn't just a governing philosophy. It's the constitutional cornerstone from which the entire administrative and judicial system flowed.
And it's all captured in that famous declaration.
It is, he declared. People are born free. No one is superior by office or lineage.
That statement, delivered in the context of the early 7th century, it's explosively radical. You have to contextualize what this principle replaced.
Right. What was the world like before this?
It was a world still heavily defined by inherited tribal authority, where your social status and your lineage, being a member of a powerful family or tribe, that determined everything. Your legal rights, your economic opportunities, and crucially, your immunity from consequence.
So it wasn't just a matter of social etiquette, right? This was hardwired into the system. If you belong to a weaker tribe, or maybe you're a new convert, or a non-Muslim subject, your ability to seek redress against a member of the ruling elite was
functionally zero. It was zero. Lineage was literally a legal shield. It was a get-out-of-jail-free card for everything.
And that must have created so much instability.
Absolutely. The pre-existing system fostered cycles of violence. If an offense occurred, justice wasn't administered by a central, impartial body. It was all a matter of tribal negotiation, blood money, or feuds that could last for generations.
So governance was just based on who had the most power.
Who could amass the most power and enforce their will through force or just through inherited prestige? It was the rule of the mighty, not the rule of law.
So when Umar declares that the system is overturned, that lineage and office grant no superiority, he isn't just making a moral decree.
No, not at all. He is stabilizing the political structure. He's transforming governance from one based on that volatile, inherited tribal authority into a predictable system, a system rooted in legal equality.
It's a geopolitical move.
Exactly. It's geopolitical as much as it is judicial. If your legal standing is determined by your actions under the law, not by your birth, you create a foundation for a unified, stable state that can transcend all those old tribal boundaries.
So the declaration basically mandates that the governing structure must operate under this new assumption.
The assumption that all individuals are equal subjects of the law. And that's the difference between a nice moral aspiration and a binding political and administrative doctrine.
Let's delve deeper into that phrase, people are born free. It carries so much weight. We're not talking solely about physical slavery, though the context certainly impacted that institution.
Right.
But in this constitutional sense, what does this freedom actually entail?
Well, in this legal context, born free means freedom from arbitrary oppression based on status.
Okay, break that down.
It means the state, and critically, those representing the state, they cannot use their position, their office, their badge, their title to infringe upon the inherent, legally recognized liberty of any person. An official is simply an agent of the law.
Not a person above the law.
Precise.
That makes the distinction so crucial. So if the governor of a province believes that he or his son is inherently superior because of their title, they're actually acting against the supreme law of the state.
Yes, and it puts a direct constitutional check on the executive branch.
And that's why the term constitutional equality is so accurate here, even though we're talking about a non-codified system.
It's entirely accurate. This declaration set the fundamental binding limitations on state power and official conduct. It defined the ultimate scope of authority.
So when the ruler himself declares that his office gives him no superiority over the lowest citizen,
that principle becomes the supreme law, and it's enforced by executive action.
and it sets the, what you'd call the standard of review for every official action moving forward. The question is no longer, did the powerful person break a minor rule?
No. The question becomes, did the official act based on the requirements of their office and the law, or did they act based on the assumption of their own superiority and entitlement?
And that distinction is the very essence of the rule of law being applied universally.
To expand on your point, think of the world as a kind of legal landscape. Before this principle, office and noble birth acted as a genuine, bulletproof shield.
A real shield.
It protected the elite from the consequences of their actions entirely. The powerful could inflict injustice, take land, strike a person, demand tribute, without any fear of reprisal from the central governing authority.
Because the local system was designed to protect them.
Exactly. It was designed for that purpose.
So this ruling, this declaration, it essentially melts that shield.
It vaporizes it. And it transforms the badge of office from a tool of immunity into a burden of immense singular responsibility.
That's a great way to put it, a burden of responsibility.
If you're an office holder, your actions are now subjected to higher scrutiny, not lower.
Because you're wielding the delegated power of the state.
Precisely. And this rule establishes a standard of mutuality. The office holder has the exact same liability, the exact same exposure to consequence as the common person.
And to institutionalize that standard back then.
It was radical. It established a precedent that the Western world would grapple with legally for hundreds of years, eventually codifying it in the concept of the sovereignty of law.
It's just fascinating how pragmatic this revolution was. It wasn't just about faith or morality. It was about creating a system where the government exists to serve a binding legal standard.
Not the whims of the person holding the office.
Exactly. Once you establish that the source of authority, whether you believe it's derived from God or the community, does not confer legal superiority on the holder of the office, you have functionally established constitutional equality.
And then you have to prove it.
Right. A grand principle, like equality before the law, remains a beautiful theory until it is tested.
And tested against the highest level of authority.
This is why the incident involving the governor's son is not just an anecdote. It's the moment of constitutional crystallization. It is the visceral proof of concept.
It's where the theoretical foundation crashes headlong into the political reality of the day, and it results in this dramatic confrontation that set an irreversible precedent for accountability.
Let's detail the specifics of the conflict. The setting is Egypt, a vast and hugely important province newly incorporated into the caliphate.
A major power center.
A major power center. The powerful party was the son of Amr ibn al-As, the governor, the highest executive official in that entire territory.
And the victim, significantly, was a Coptic Christian. This is key. He's representing a minority group and, arguably, one of the least powerful strata of society.
So you have the maximal power imbalance possible.
It's perfectly set up for a test case.
The incident itself arose from something almost trivial. A race, maybe involving horses, which led to a dispute. But the crucial element isn't the race itself.
No, it's the specific offense. The governor's son, enraged in the dispute, struck the Coptic Christian.
And the son's justification is the ignition point that turns this from a simple assault into a full-blown legal crisis. He didn't just strike him. He boasted loudly and clearly, "I am the son of the noble."
And that's not just trash talk.
No. This explicitly links the physical injustice to claimed inherent privilege. He's asserting that his high status made his actions acceptable and, more importantly, immune to challenge by a commoner.
That phrase, "I am the son of the noble," is a direct and frankly an arrogant challenge to Umar's constitutional declaration.
The one we just talked about. No one is superior by office or lineage.
Exactly. The son was effectively arguing that his father's office and his family name superseded the caliph's foundational law. He was testing the system.
So what does the Coptic Christian do? He knows that seeking justice locally, through the governor's own administrative system, would be
Useless. Or even dangerous for him.
right. So he takes this incredibly daring and potentially life-threatening step of circumventing the local authority entirely. He traveled all the way to Medina, the capital, to complain directly to Umar.
And this procedural detail is so crucial. It illustrates the reserved, centralized authority of justice.
What do you mean by that?
The victim knew that while local authorities might be compromised by high-status kinship, the central executive authority, the caliphate, reserved the absolute jurisdiction to intervene immediately when high-status officials were implicated in injustice.
So the caliph himself was the ultimate court of appeal against executive overreach.
He was the final backstop.
And how did Umar handle this political powder keg? Did he commission some secret investigation? Did he defer the matter back to local courts to save the governor face?
No, nothing like that. The source tells us Umar summoned 3 parties simultaneously to Medina.
3 parties.
The governor, Amr ibn al-As, the accused son, and the complainant, all 3 at the same time.
The triple summons. That is absolutely brilliant and must have been politically terrifying for the elite.
Oh, completely. By forcing the powerful governor to stand alongside his accused son and the victim in the capital, Umar was signaling several things instantly.
Okay, what were they?
First, that the father's office provided absolutely no protection or excuse, 0. Second, that justice would be immediate and public. And third, that the central authority controlled the narrative.
It removed any possibility of the governor tampering with evidence or delaying the process or...
And intimidating the victim. It took all of that off the table immediately.
Let's just zoom in on that moment of the summons.
Right.
Why 3 people? Why not just deal with the son, the one who actually committed the act?
Because the crime wasn't just a physical assault. It was an assault on the constitutional order.
Ah.
The son committed the physical act, sure. But the governor's authority provided the context that enabled the boast in the assumed immunity in the first place.
So by summoning the governor, Umar was putting the entire administrative structure of Egypt on trial.
Implicitly, yes. He was asking, how could this have happened under your watch?
And here's where it gets, really interesting. Once the parties were assembled, the facts were clear. This wasn't a judicial inquiry into guilt.
No, the facts weren't in dispute.
It was the execution of a constitutional principle. So, detail the revolutionary judgment for us.
Umar ordered the complainant, the Coptic Christian victim, to strike the governor's son back with the same whip that had been used in the assault.
Wow. With the same whip.
With the same whip. This is justice in its most direct, immediate, and literal form. It's an act of perfect, unassailable equivalence. It ensures parity and consequence.
It's not just punishment, it feels like a restoration. The son had tried to use his status to humiliate the Coptic Christian, to reduce him to a lower status through violence.
Right.
So the act of striking back, sanctioned by the supreme authority, immediately restored the Coptic Christian's dignity and affirmed his equality in a very physical way.
And we cannot overlook the profound political statement of this public enforcement. This wasn't done in a private chamber. This was constitutional equality enforced in public.
Making the principle visible, undeniable.
And universally understood by both the powerful elite and the general populace. It wasn't a fine, it wasn't a short jail term, it was a physical demonstration that privilege does not stop a whip guided by the law.
I have to pause here and ask, wouldn't the caliph risk massive instability by publicly humiliating one of his most powerful provincial governors and his family like this? Was this decision politically naive, or was it politically brilliant?
Oh, it was brilliantly pragmatic. Political stability in a vast empire relies not on the loyalty of a few high-ranking individuals,
But on the trust of the masses.
exactly. By publicly humiliating the governor's son, Umar sent an electrifying signal to every single subject, Muslim and non-Muslim, powerful and weak, that the caliphate's justice was fearless and applied to everyone.
That would create a kind of loyalty and trust that far outweighed the potential disgruntlement of one powerful family.
Of course, it substituted the loyalty of the governor with the loyalty of the entire province.
But the accountability, and this is just astonishing, it didn't stop with the son. The source tells us of the second, even more shocking instruction.
This is the part that's truly incredible. Umar then offered the whip to the complainant to strike the governor himself.
To strike the governor.
The governor. This is a remarkable standard of accountability. It establishes what we would now call vicarious responsibility.
Explain that term.
It's the idea that you can be held responsible for the actions of those under your direct command, or, in this intimate case, your dependent family. The governor, Amr ibn al-As, had not personally struck the victim.
No, he was miles away.
But he was held accountable for failing to restrain injustice, or, perhaps more damningly, for enabling his son's sense of immunity through the prestige of his office.
So his failure wasn't a legal technicality. It was a failure of moral and constitutional governance.
Exactly. His office, his power, did not shield his son, and worse, his negligence made his high office a direct liability. This transformation of power from a privilege into a burden of profound responsibility is the core constitutional lesson here.
And this leads us directly to the iconic declaration, which the source material says serves as the ratio decidendi of the entire event.
That's a great term.
It is. For the listener who isn't familiar with legal jargon, the ratio decidendi is the foundational legal principle or the binding reason for the decision. It's the heart of the judgment itself.
It's the why. And the why here, the binding legal reason for the decision, is captured in that famous quote.
Since when have you enslaved people when their mothers gave birth to them free?
That's just so powerful.
Let's truly unpack that quote, because it's more than just rhetorical flair, isn't it?
Oh, much more. It links the specific physical act of striking back to the foundational principle of universal freedom. The injury inflicted by the son wasn't just physical pain. Umar interpreted it as an attempt to reduce a free individual to the status of a slave. By asserting superiority and using violence based on that status, the governor's son had attempted to revoke the constitutional freedom guaranteed to the Coptic Christian.
So in other words, the caliph recognized that oppression based on title or rank is a form of enslavement, even if it's just momentary.
It is. It treats the victim as property rather than a legally autonomous individual.
And by declaring this in front of the governor and his son, Umar reinforced that the state's power originated from the community's trust, and that trust was fundamentally conditional on maintaining this equality.
If you betray that trust, your power is stripped away, regardless of your title. It is the clearest possible demonstration that the rule of law sits above the rule of man. It's an affirmation of due process through the lens of fundamental equality.
And the story concludes with the governor's son being struck, the governor being confronted, and the Coptic Christian returning home having received justice directly from the central authority. The political message was delivered, loud and clear, across the entire realm.
It was an unforgettable lesson.
And one that still echoes today.
Absolutely. If we connect this 7th century narrative to the bigger picture, the concept established by Umar is not merely a historical curiosity or some moral ideal.
No.
It is the absolute cornerstone of modern constitutionalism that we see enshrined in laws globally today.
It provides the administrative blueprint.
Yeah.
So what are the key elements specifically that were affirmed in that action that we see codified in legal systems today, 1,000 years later?
Well, there are two critical elements which we must constantly police that were affirmed. First, the assertion that there is no immunity by birth. Your family name, your lineage, your inherited wealth or status grants you no special legal status.
Not at all.
Second, the assertion that there is no privilege by office. Your position in the bureaucracy, your political title, your rank does not grant you exemption from the law.
And crucially, there's a third element which the whip physically demonstrated. Equality must be enforceable against the powerful, not just symbolic or written on parchment.
That's the real test.
The strength of any law is measured entirely by its capacity to restrain the most powerful individuals in society.
That's the true test. Modern courts worldwide constantly affirm that status cannot shield wrongdoing. And the source material points us toward a key UK parallel, R.V. Prince Ernest Augustus.
A perfect modern demonstration of this principle.
Yes, being tested in a contemporary context involving high hereditary status.
Many people might know the names, but may not know the specifics of the legal challenge. Tell us about that case and why it's so relevant here.
In short, Prince Ernest Augustus of Hanover held dual British and German citizenship, and the legal issue arose under the British Nationality Act of 1948. This act established very clear requirements for maintaining British citizenship, including registration.
And the prince hadn't met those requirements.
Correct. He had not met these necessary registration requirements.
So the core legal question was whether his unique status as a descendant of Sophia, Electress of Hanover, which had historically granted specific rights under the Act of Settlement, meant he was exempt from the standard statutory requirements that applied to all other citizens.
Exactly. The case was essentially asking, does your noble lineage and proximity to the crown create a legal loophole that overrides clear, specific, modern legislation?
So the court had to decide if that ancient principle of hereditary privilege still held any sway over the modern statutory principle of equality before the law.
A direct confrontation, in a sense.
And what was the outcome?
The outcome affirmed the principle of universal applicability. The court ultimately held that while his hereditary status granted certain ceremonial titles, it did not grant him immunity from the clear procedural requirements of the British Nationality Act.
So he was held to the same standard as any other person.
The same standard. The dignity of the individual and the supremacy of the codified law overrode any claimed privilege derived from lineage or hereditary rank.
That's a crucial linkage. It proves that the constitutional struggle against immunity by birth, which Umar dealt with using a whip,
Is still playing out in high courts today, albeit with parliamentary statutes instead of executive decrees. It grounds the historical anecdote firmly in contemporary legal reality.
the principle is identical.
The law must be blind to the bloodline, and constant judicial vigilance is required to keep that barrier between privilege and procedure firmly in place.
Now let's pivot to the specific connection made in the source material regarding Pakistan's jurisprudence. How do Pakistan's courts apply this principle today, specifically under Article 25 of the Constitution?
Well, Article 25 of the Constitution of Pakistan guarantees a comprehensive right that all citizens are equal before the law and are entitled to equal protection of the law. This is the bedrock.
The foundation.
And Pakistan's courts have had to interpret this robustly, particularly in a context where centralized bureaucratic power is often seen as inherently superior. The courts have consistently asserted that discrimination based on holding a public office or granting undue favor based on political office is explicitly unconstitutional.
Can you give us a concrete example of where this principle is tested under Article 25 in Pakistan? We need to move beyond general statements to show the learner how this plays out in real life.
A classic test case is judicial review of executive action, particularly regarding, say, resource distribution or land allocation. Historically, high-ranking military or civil officials might receive preferential treatment, like subsidized land or waivers on regulatory fees, purely because of their status.
So the use of public office not just to commit a wrong, but to acquire an unfair advantage over the common citizen.
Precisely, and the Pakistani Supreme Court has intervened many times under Article 25 to strike down such preferential treatment.
On what grounds?
Arguing that these actions violate the Equal Protection Clause because they grant privilege based purely on status or office. The jurisprudence demands that state officials, from the highest bureaucrat to a local magistrate, are subject to the same legal process and constraints as any common citizen seeking a public good or facing a legal challenge.
This ensures that the state apparatus is subordinate to the Constitution. Without this robust application of Article 25, the state would simply become a tool for the powerful.
Which is exactly the lineage-based system that Umar was fighting against centuries ago.
It's the same fight.
And this commitment extends to holding officials accountable for misconduct. They cannot claim state protection when facing criminal liability for an official act done improperly, nor can they claim privilege against civil liability.
You mean tortious conduct?
Exactly. Harmful, wrongful actions committed in their capacity. Their office offers them no blanket immunity.
That concept, tortious conduct, can sound complicated. Can we simplify it for the listener?
Sure. Think of it this way. If a government official, using their state-issued vehicle, acts negligently and causes harm, they and the state can be sued by the affected citizen, just as if they were a private individual.
So their official status doesn't give them a free pass to cause harm without consequence.
Not at all.
This systematic accountability brings us back to that powerful summarizing statement provided in the source material. It's a profound warning across all jurisdictions.
It is. Justice collapses the moment privilege enters the courtroom.
That is a deeply chilling and realistic sentence. The implication here is that privilege is inherently corrosive. It doesn't just bias the outcome in a single case.
No, it fundamentally undermines the very legitimacy of the system itself.
If a citizen sees that their powerful opponent's wealth, their title, their political position means the court will inherently favor them, then the system has already lost its moral authority.
Even before the gavel falls.
Exactly.
And that's why the principle established by Umar demands not just passive fairness, but judicial courage.
What do you mean by that?
The active, aggressive prevention of privilege's entry into the consideration of law. The judge must act like Umar did, treating the powerful litigant or defendant as just another subject, stripping them of their titles before they even approach the bar.
Let me introduce a moment of necessary skepticism here. When the governor's son was struck, it was swift, immediate, and visible. Public shaming.
Yes, very visceral.
But in modern systems, justice is slow, it's expensive, and it's often opaque. Does that slow, bureaucratic nature of modern constitutionalism dilute the impact of the principle, even when it is legally applied?
That's a critical challenge. It's a really good question. The immediacy of Umar's justice created an overwhelming psychological deterrent. Modern systems have to rely on the certainty of eventual consequence to achieve the same deterrence.
So it's certainty over speed.
It has to be. If the powerful know that the process, though slow, is utterly unavoidable and equally applied, the deterrence remains. The danger lies when the powerful can simply use their resources to delay justice indefinitely.
Effectively achieving the same immunity that the governor's son briefly believed he possessed.
Precisely. The principle of equality demands speed and accessibility as much as it demands impartiality.
And this is why this entire discussion is so relevant to you, the listener, today. This is not just history or theoretical law. It is the definitive measure of a functioning, just society.
Absolutely.
Every citizen, every business, every institution relies absolutely on the knowledge that the person with the most power, the governor, the prince, the CEO, the head of the ruling party, is subject to the same restraints, the same accountability, and the same punishment as the person with the least.
And if that confidence breaks down, the social contract breaks down. The lesson from the 7th century remains our primary defense mechanism against tyranny. The law must check the executive and the elite, and it must do so fearlessly.
So as we wrap up, let's bring it all together.
Okay, so to recap our journey, we started with the revolutionary principle of born freedom, that no status or office confers superiority. We saw its dramatic, high-stakes enforcement in the case of the governor's son,
where a public, immediate, and literal application of justice affirmed universal liberty.
and even established the governor's vicarious responsibility, which is a key point.
Right, and we connected this foundational wisdom directly to its continuing necessity in modern legal frameworks. We demonstrated its life in the courts of the UK through R.V. Prince Ernest Augustus and in Pakistan's robust application of Article 25 against the abuse of executive office.
And the key takeaway time and time again is the absolute enforceability against the powerful.
Which brings us back to the heart of the source material and its final, profound moral lesson.
It's the whole point, really.
So what does this all mean? The ultimate conclusion, the core idea is this. A nation becomes just when the powerful fear the law more than the weak fear power.
That flips the conventional power dynamic entirely, doesn't it? Justice is not achieved by charity or kindness from above. It's achieved by systemic, inevitable restraint.
When the powerful act justly out of operational respect for the impartial consequences of the law.
When they fear the law more than they cherish their privilege, that is when the system achieves fundamental security and stability.
Fear, in this constitutional sense, is simply that healthy operational respect for consequence. It is the necessary tension that keeps the social order from dissolving into hierarchy and arbitrary rule.
And this raises an important question, something for you, the listener, to mull over long after this deep dive ends. We saw the governor fail to prevent injustice.
He enabled it.
He enabled it through his own complicity, or at least his failure to enforce the principles in his own sphere of influence. For the constitutional system to truly work today, how much responsibility rests not just on the courts to punish privilege after the fact, but on the powerful themselves to proactively dismantle their own capacity for injustice?
That's a great question. Do we rely solely on the judicial consequence after the transgression has already happened? Or do we need better mechanisms today, in executive ethics, in parliamentary review, or in public transparency, that can ensure the powerful proactively self-regulate?
That they fear the law enough to prevent the transgression from occurring in the first place.
Exactly. How do we build systems that make the governor fear the law before his son ever lifts a whip?
It challenges us to look beyond just the punishment and into the fundamental structure of moral governance, which, as we saw today, is the ultimate goal of equality before the law.
That is a powerful and necessary thought to end on. Thank you for joining us on this deep dive into the historical and modern foundations of constitutional equality.
We hope you gained clarity and context from this detailed analysis of the source material provided by Mr. Zahir Ahmad Mir.
Until next time.